So friends, welcome you all to the current event of 17th of December 2020. It's our lecture related to Target UPSC Prelims 2021. Now what it says, see, first news is about an important committee mooted by Supreme Court. Before that, the most important quote for essay, today's quote is, true education must correspond to the surrounding circumstances or it is not a healthy growth. You can use this quote while writing essay or all other kinds of examination. Now, first news, Supreme Court moots panel for farmer government talk. Now, this news they might not ask you in prelims, but this particular news is very important from your mains examination point of view, as this particular news amounts to judicial adventurism or judicial terrorism or judicial arrogance. Why this news is important? It is very interesting. See, the bench observes that current negotiations have broken no grounds and are bound to fail between farmers and government. Recently, the negotiations or the protests are going on by farmers regarding three important bills passed by the government of India in the month of September 2020. Governments are not happy with the bill. They are demanding for repeal of the bill, but government is adamant. Government is saying that we are not going to change the bill. Our purpose is not about the news. Our purpose is to understand three important terms related to this news. One is judicial review, second is judicial activism, third is judicial adventurism. Basically, this is an arena of separation of power. There should be a separation of power. But here, when judiciary establishes a committee, when judiciary forms a panel for having negotiation between government, farmers and third party, it means somewhere judiciary is violating its own ground. Judiciary is encroaching upon the ground of executive, or judiciary is encroaching upon the grounds of legislature. Why it is important? So, for this we will try to understand three important terms. First is judicial review. What is judicial review? A simple process of examining or inquiring the legislative action or executive action, whether these legislative and executive actions are in line with the constitution or not, whether these executive actions are in line with the law or not, it is a kind of judicial review. Here judiciary examines the legality of executive or legislative action. Second is judicial activism. What is judicial activism? In judicial activism, judiciary fills the gap or vacuum created by inaction of legislature and executive. Whenever legislature and executive fails to perform their duties, that is, fails to perform a law or fails to implement that law, which is leading to violation of liberty, violation of human rights or violation of constitutional norms, in this case this entire arena is being filled by judiciary, which is judicial activism. Judicial activism is a positive sign. Then third one is judicial adventurism. So whenever judiciary encroaches upon the arena of legislature and executive, it is called as judicial adventurism, judicial terrorism, judicial arrogance. It means in this particular case, actually having discussion with the farmer is prerogative, or it is the area of executive. But here judiciary herself has formed a panel to discuss with farmers and government. So here judiciary has encroached upon the arena of legislature and executive. So this can be called as judicial adventurism, which is unnecessarily unwarranted. So here in simple term, in this third case, there is violation of separation of power, which is the most important basis of functioning of parliamentary form of government. I will go in details of this particular news. Here, what is the meaning of separation of power? Here remember, separation of power divides the mechanism of governance into three branches of government. One is legislature, second is executive, third is judiciary. This every organ of government has been given with one of the most important function, and that function is legislature makes a law, judiciary executes that, executive executes that law, implements that law, and judiciary examines the legislative and executive validity. But here in this particular case, due to this formation of panel by judiciary, it is violation of area of executive and legislature, and it is judicial adventurism. It is violation of separation of power. Now, what it says, Each organ should have different persons and different functions in capacity. One organ should not interfere in the functioning of the other organ, as it is said. One organ should not exercise a function which is adversarial or which is against another organ. Then what is the significance of this doctrine? It keeps away autocracy, safeguards individual liberty, it helps create an efficient administration, judiciary's independence is maintained, prevents the legislature from enacting arbitrary, unconstitutional and whimsical laws and going as per the norms, rules, regulations of the constitution. Then what is the importance of this particular and what are the constitutional provisions related with the doctrine of separation of power? It is Article 50. Article 50 talks about separation of executive from judiciary. It is part of directive principles of state policy, where it has been clearly mentioned that in case of India, there will be separation of executive from judiciary, which will prevent any kind of violation of principles of natural justice. Then Article 123 talks about ordinance making power of President of India, like Article 213, which talks about ordinance making power of Governor of States. Article 121, Article 211 and finally Article 361, all these are the constitutional provisions related with the separation of power. We are discussing this important case study relating with the separation of power. Then what are the important checks and balances available in case of Indian Constitution to prevent any kind of violation of this separation of power? We have the mechanism of judicial review. The mechanism of judicial review is supported by Article 13, then Article 32, then Article 226. I repeat once again, the doctrine of judicial review is supported by certain important constitutional provisions like Article 13, Article 32 and Article 226. Then strike down the laws which are unconstitutional, which are against norms, which are against law. Here also, legislature also reviews the functioning of the executive through various mechanisms like questionnaire is there, adjournment motion is there, calling attention motion is there, short duration discussion, half an hour discussion, then point of order motion, no confidence motion. Through all these various mechanisms, legislature exercises its reviews the functioning of the executive. Judges are appointed by executive. This we have gone through 4 important cases: first judge's case, second judge's case, third judge's case and fourth judge's case. This fourth judge's case has nullified the National Judicial Appointment Commission and maintain an independence and impartiality of the Parliament. So this was the first issue that is very, very important for you to remember. This particular point you can remember while writing your mains answer. We will be coming with more such number of case studies and the important issue that should be discussed. So this news is related with the mooting of new panel or forming of new panel by Supreme Court, and how this formation of new panel by Supreme Court violates the very doctrine of separation of power. So thank you very much from my side. We will be coming with more number of such cases in the days to come. Thank you.